The United States Supreme Court just handed Donald Trump what appears to be two major victories, or at least one plus victory, related to Elon Musk and his Department of Government Efficiency, granting a stay and blocking a lower court and a lower appellate court's decision to not allow DOGE to have access to Social Security. I'm going to have on Legal AF in the next couple of days Representative Richie Torres out of New York to talk about these particular issues. But we also broke it down on Legal AF, the podcast. And here's a clip.
Supreme Court cases. It was, the Supreme Court does these things where they'll make some terrible rulings and then they'll dump in unanimous rulings the same week. Like they'll dump like a few 9-0 rulings and be like, see, we all get along. This is pretty normal. And then they'll make like a ruling this week. Everybody's Social Security information goes to Elon Musk immediately. DOGE gets everybody's Social Security data forthwith. That was one of their rulings. And then the other ruling they made was severely limiting the public's right to get discovery from DOGE. And when you read the Supreme Court's ruling, first off, they they convert a emergency stay request into a petition for certiorari. And for those what it means, like they treat it as though this is one of those cases that have taken 7 years to get to the Supreme Court, going through all of the, like, we'll convert, okay, what are you, like a scientist? We're going to convert this emergency request to simply pause discovery into DOGE, as if this case had been taking place for many, many years, into a writ of certiorari, and we're going to find in favor of Donald Trump on a 6-3 basis. And they didn't say you can't get any discovery of DOGE, but when you read the ruling, I don't know what's left of the ability to get. They said you must definitely think through the strong interests of the executive branch to assert executive privilege. The way I read it, you really can't get any discovery of DOGE, even though they try to pretend like there's some carve out for things. So Popok, those were the two rulings. Number one, your Social Security data, yes, it goes to DOGE. Number two, you don't get discovery really into DOGE, or it's very limited. So you don't even know what DOGE is or what they're doing with your data. Those are the 1, 2. But then they said, all right, we'll give you 3 9-0 rulings. You still like us, huh?
Yeah.
That's what they did.
Yeah. And the two decisions on DOGE are inconsistent with each other, because if DOGE is a legitimate agency that is allowed to look at your and my most private and confidential personal, medical, and financial data, then why aren't they an agency for the purposes of Freedom of Information Act public records request? I don't know how you can sort of do both of those things at the same time. And one comment, he is in our ecosystem. I do like him, but I don't like the shorthand I saw in Josh Gerstein that we put up there. 3 libs dissent. First of all, I wouldn't consider the 3 members that dissented to be liberal in that traditional sense. I like calling them moderate, or the democratically appointed wing of the Supreme Court. But yeah, I don't want to use the shorthand of our adversary, the libs, the libtards and all that. It just, okay. So Ketanji Brown Jackson is doing a great job at calling out the failings of this United States Supreme Court 6-3 majority. And to put it in context, the Supreme Court has complete control over the timing of all of its process and procedure, when it allows cases to go forward, the timing of them, the order of them, oral argument, when opinions are going to drop as they're finishing up through the end of June this term. Now, mixed in with the decisions we've been waiting for since, some on emergency petition and some on full briefing. Got a mixed bag here. We're still waiting on decisions that have to do really with the Biden administration and issues that were raised then, interspersed with these 16, 18, 20 emergency applications that have been filed. And the emergency applications are being exploited. Let's call it out, by the Trump administration since day one is their strategy. I'm sure led by John Sauer, the number 4 in the Department of Justice, Stephen Miller, and the rest, to try to, through velocity and ferocity, to stampede the Supreme Court into making ideological decisions without an appropriate record, without oral argument, without deliberation and the deliberative process that they're used to. You and I, when we went to law school, God, I can't even remember a case that was in one of our textbooks that came up through the shadow docket. I didn't even really know what the shadow docket was in that way from law school training. Okay. Every case in our book, or you're younger than me, your iPad, was a case that was proper record below, 3 briefs, oral argument, maybe supplemental briefing, deliberation, exchange of opinions internally with law clerks over late night pizza and drafts and vote changing, and then boom, we got a decision. That's gone. Trump administration figured if we make, as it was called out by Ketanji Brown Jackson, if we call everything an emergency, and the emergency for her is, I don't understand the emergency. You just don't want to be what every other litigant needs to be, which is to go through the proper process. What's the emergency? Like you not being able to get your hands on all of our Social Security information. What's the emergency? Why can't you go through a normal process and get a ruling 6 months from now that then gets adjudicated? If you're delayed a year in trying to reform Social Security, what's the loss really to the American people? So that's her calling out. So the reason I mentioned that they're in charge of everything and the exploitation that's going on is that they've come to a head now with all these summer rulings. So John Roberts obviously gave out the order 3 days ago to drop in sequence all the 9-0 kumbaya moments. And I'm sorry, I'm very callous about all of this. And I found it to be slightly insulting that the 3 decisions that came out 9-0 were written by Ketanji Brown Jackson, Sotomayor, and Kagan, one each. Reverse discrimination, a white person who is straight can sue now for discrimination if their boss is LGBTQ plus and they have an allegation of discrimination against them. And that was written by Ketanji Brown Jackson for a 9-0 court. Like, okay. Catholic charities, if your state gives a tax exemption or an unemployment exemption for a religious organization, they can't pick and choose which religious organizations they're going to give it to by claiming, well, the Catholics don't proselytize. They don't try to convert people. They just evangelize. So that's not the type of religion that we're giving exemptions to. No. All right. So that gets written by Sotomayor, a famous Catholic. And the last one is, the last one was written by Kagan. I forget what the last one's about. I'll come up with it before we're done. So we got those 3 9-0s, right? Then DOGE drops. Boom, boom, one after another, both on emergency applications. And the 6-3 split happens on both of them. Ketanji Brown Jackson could have just dusted off what she wrote a week ago because she wrote the exact same thing. The 2 rulings, as you said, Ben, one in Social Security Administration against or with AFSCME being sued by the largest federal workers labor union in the country. That one has to do with DOGE being granted access to all of your and my most personal financial information, medical information, and the like that's buried inside of the Social Security Administration. All the people that have looked at it have said, why can't you get stuff that's anonymous? Why do you have to know Michael Popok's personal file in order to root out whatever you're rooting out? And this is all under the Treasury Department, but it implicates the Privacy Act of 1974, which keeps this information out of the hands of people who unless they have a real need to know and they're inside the government. So Jackson put it, she had a great metaphor for this. She said, in attacking the emergency application process, she said, in essence, the urgency is on page 2 of her dissent. The urgency underlying the government stay application is the mere fact that it cannot be bothered to wait for the litigation process to play out before proceeding as it wishes. And then she takes on the court. She said that once again, this court, meaning the 6 in the majority, Roberts and Amy Coney Barrett included, dons its emergency responder gear like firefighters, rushes to the scene, and uses its equitable power to block the lower court's decision to fan the flames rather than extinguish them. The firemen who starts the fire instead of puts them out, is what she says. And then she goes through the entire case and she says, I just don't understand why, with a 9-6 decision by the en banc panel of the lower court, and with this lack of urgency and any irreparable harm, why we are granting a stay. And I therefore dissent. And she then gives her fear on the bottom of, towards the end of her decision. She says the court opts instead to relieve the government of the standard obligations, jettisoning careful judicial decision-making and creating grave privacy risks for millions of Americans in the process, throwing away well-established laws that are on the book. She's basically bemoaning what trial judges are thinking, which is, what are we supposed to do? We're issuing the rulings, and every time we issue a ruling, just because it's an emergency application, the Supreme Court is tearing it down. 2 weeks ago, I said to our audience that it was about Trump was running about 50-50 at the Supreme Court, even though he was losing 90% plus at the lower court level. It's now he's winning 3/4 with these new decisions, 3/4 of the decisions that are being brought to the Supreme Court, only emboldening Donald Trump to continue with his strategy. It is reinforcing his emergency application strategy, and the inconsistency. I'll leave it on this, Ben, between trying to reconcile these back-to-back decisions on DOGE, the one that says, well, we don't really like the way the trial court analyzed whether DOGE is an agency or quasi-agency for purposes of public records requests. So we're going to send it back to you, but with such tight instructions about the unitary model of the presidency and deference being, of course, we have to give more deference to the Trump administration on this. So go look at it. I'm not saying you won't be able to find a way for DOGE to have to give public records and FOIA responses, but we don't like the way you did it now. So go away. And here's the stay. Same 6-3 split. But these are inconsistent for me, because I don't know how you can say that DOGE has the right, if they're not an agency that has the right to look at my privacy data, then what are they? And if they are an agency that gets to look at my privacy data, then why don't I get to find out about it in a Freedom of Information Act request? And what we're watching finally, Ben, is this struggle. I think I end up in the exact same place you do when you started with, I think if it's like a major abuse of power, they won't. If it is, I think it's this battle over the unitary presidential model. And now we've seen the voting. Roberts and Amy Coney Barrett are more likely than not to side with Gorsuch, Kavanaugh, Alito, and Thomas, and on unitary presidential model, giving the executive branch a load of deference when it comes to his policies. I had a little hope that on occasion, and maybe on occasion they won't, Amy Coney Barrett and Roberts would sort of stay in the middle and pick and choose their moments. But I don't like the results in the DOGE decision. There's one last case that you and I need to keep a close watch on involving DOGE and Judge Chutkan, which has not been decided by this. There's a dozen other cases out there, but the one that I'm most focused on and ties back to the Musk-Trump spat is the case that she just granted or denied motion to dismiss and said that 14 attorneys general can bring a case to argue that DOGE and Musk was improperly appointed under the Constitution, which would make null and void all of their actions. That was not before the Supreme Court yet. But once that got up to the Supreme Court, based on what you're seeing, what do you think the court's going to do with the Chutkan case?
Well, I mean, I think the Supreme Court, going to the unitary executive theory, give Donald Trump what he wants, I think, on the Chutkan case. I think that anything other than act like an outright dictator and eliminate the courts, I think this Supreme Court on a 6-3 basis will generally side with Donald Trump. And it goes back, Popok, to their absolute immunity ruling. That was their big tell where they really were. And the tension between the right-wing justices and I call them the liberal people call them liberal. I call them the pro-democracy justices. But for those not, who use the traditional conservative liberal kind of framing, you had the three pro-democracy justices basically saying, of course, Donald Trump's going to act like a dictator. And then you had John Roberts saying, no, I don't think that's going to happen. I'm worried that if we have these limitations on the executive, they're going to be chilled. We think that the president will act in good faith. and then you have the liberal justices or the pro-democracy justice saying he's not going to act in good faith. What are you talking about? He's not going to act in good faith. You can't apply a normal framework of the presidency to the times we're living in. And then John Roberts saying, yeah, we're just going to treat it like these are normal times. And we think that the president should have all this power because they'll exercise it in good faith. And only when Donald Trump then takes that power and he's like, watch me do everything, then the Supreme Court basically goes, we still need courts.
Welcome back. We created Legal AF 5 years ago. And if you didn't know why we call it Legal AF, well, now you do. We sit at the intersection of law and politics every week, every hour. We do it on the Midas Touch Network. We do it on Legal AF. The new, it's not new anymore. It's 8 months old. The YouTube channel that we're working hard to get by the end of this month to 700,000 subscribers with your help. We could use the help on the podcast too. We got competition out there, folks. Let's be frank. We're the number one law and politics YouTube podcast, according to rankings, top 50, 60 overall. But we could use some help on the audio side. So download the audio of the podcast every Wednesday and Saturday. Watch the podcast on YouTube. We do both. Some people think, oh, you're on YouTube? Or oh, I didn't know you had an audio version. We have both for your listening pleasure. You can consume Legal AF in many different ways. The podcast, the YouTube channel, the Substack. But we're glad you're here because we are our own marketing department. And without you, we got nothing. So until my next report, next Legal AF, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.